Hi, I'm going to evaluate Priceline's terms of use and give my analysis of it. In order to do so, it's important to ask a few questions in order to help you understand the outcome of my evaluation. These questions are, is it a valid contract? If you have a dispute with Priceline, can you sue them? Are visitors bound to the terms and conditions, or do they have to click I agree? Are there any changes that could be recommended? Well, in order to determine if Priceline's terms and conditions are a valid contract, it's important to discuss some previous cases that may help determine the answer. In an important case, Harris versus Blockbuster, a Texas woman named Catherine Harris sued Blockbuster after it used Beacon to share her movie rentals with her Facebook friends. Just so you understand what Beacon was, it was part of Facebook's advertisement system, and that it sent data to Facebook from third-party external websites. The suit was seeking class action status, even though Blockbuster had in its online terms and conditions that disputes could not be brought to court. Priceline's terms of use states that any and all claims must be resolved by binding arbitration or in a small claims court. It also states that these limitations apply to any claims against Priceline, subsidiaries, or its affiliates, or any travel service providers offering products through Priceline's site. It goes further on to say that the arbitrator's decision will generally be final and binding with no right of appeal. In the Harris case, Judge Lynn said that Blockbuster's online terms and conditions are unenforceable. But the reason for the judge's ruling was because the company had stated that they had the right to change the terms at any time. Although the case had challenged arbitration, it was not because of the arbitration clause that the judge ruled in Harris's favor, so the arbitration clause in Priceline's terms and conditions are valid. Surprisingly, in doing further research, I've found that a very large percentage of the terms of use policies that I've read have arbitration clauses in them. An example of one website's clause in their terms of use says, all disputes between you and Oath will be resolved by binding arbitration. You thus give up your right to litigate disputes with us in court, except for matters that may be taken to small claims court. I found several sites that all included arbitration clauses. According to Priceline's terms and conditions, arbitration is to be used for any disputes against the company. So as soon as a consumer buys or transacts with Priceline, an e-signature is used and the terms and conditions are accepted. So arbitration is the only legal way to solve a dispute with Priceline. This answers two questions. It is a valid contract, and Priceline cannot be sued unless it is done in a small claims court. Are visitors bound to the terms and conditions on the Priceline website, or should they have to click I agree? In order to facilitate electronic commerce, Congress enacted the Electronic Signatures in Global and National Commerce Act, or the e-Sign Act. The e-Sign Act states that the enforceability or validity of a contract, electronic record, or signature for a transaction cannot be challenged solely because it is in electronic form, or because an electronic signature or record was used in forming the contract. If a business is legally required to make information available to consumers in writing, it can be delivered electronically as long as there is prior compliance with the e-Sign Act's requirements. There are 6 steps to have consumer consent. Step 1 is to have available paper copies or provide paper delivery options. Institutions must inform the consumer in a clear statement of any right or option to have the record in a non-electronic form, the right to withdraw consent, and the consequences for withdrawing the consent, and any fees that may be imposed if there was a withdrawal of the consent. Consumers must also be informed of their right to request a paper copy. Step 2 is to have consent choices. A financial institution must inform the consumer in a clear statement whether consent relates to a transaction only, or whether consent relates to a broader category of information. Step 3 is to notify the consumer of the action needed to be taken. Financial institutions must disclose to consumers the procedures to withdraw consent and to notify the financial institutions when contact information for the consumer changes. Step 4. Is the hardware or software requirements to access and retain electronic records? Step 5 is to affirmatively consent. The e-Sign Act requires that the consumer must provide consent electronically in a manner that reasonably demonstrates that the consumer can access information in an electronic form that will be used to provide the information that is the subject of the consent. Step 6 is the after consent disclosure statement. This statement must provide consumers with information detailing any revised hardware or software requirements for access to or storage of electronic records. The consumer must also be informed of their right to withdraw consent without the imposition of fees for such a withdrawal. After this step, the consumer's affirmative consent must be obtained again. Prior to the e-Sign Act, the Uniform Electronics Transaction Act had been established. Under the UETA, electronic signatures are valid whenever there exists an electronic symbol or message combined with the signer's intent to authenticate a contract. Both of these acts have given electronic signatures the same legal weight as a signature on a piece of paper. In a case in Arkansas, Barwick versus Geico, in 2011, an insurance client waived the minimal medical coverage on her insurance plan using a click-to-sign e-signature. Later, she was involved in an accident that caused her to incur medical expenses and claimed that the e-signature was not binding because it wasn't in writing. Barwick's lawyer argued that the statute, like UETA, did not apply if the insurance statute stipulates that contracts have to be in writing. The Arkansas Supreme Court agreed with the insurance company, Geico, and so no conflict between the auto insurance statute and the electronic record, and saw that the electronic record satisfied the law. So, in conclusion, I believe that Priceline's terms and conditions are very good. They are necessary to set the rules and guidelines that Priceline users must agree to in order to use the website. It is also important to inform users of Priceline's ownership of content and copyrights, trademarks, and intellectual property. Priceline has also clarified the jurisdiction of its website, and the disclaimers in the terms and conditions have limited the liability of Priceline. Priceline, in my opinion, has a very complete and comprehensive terms and conditions policy. It's my assessment that no changes need to be made.